The email arrived at 6:42 a.m. Subject line: Emergency custody hearing, attendance restrictions apply. I read it twice before I opened the attachment. Then a third time after. Petitioner requests that respondent appear alone. No character witnesses. No third-party statements. Alone. That word has weight when it's written in legal font. My sister had filed for emergency guardianship over our mother the night before. I found out through a court notification. Not a phone call. Not a conversation. A notification. The hearing was scheduled for 1:30 p.m. the same day. Family Court, Room 312. Downtown. Expedited due to immediate cognitive risk. Cognitive risk. That's how they framed it. Our mother had missed 2 utility payments and once forgotten where she parked her car. That was the emergency. By 7:15 a.m., my sister texted, "Don't make this dramatic. Just agree. You're never here anyway." I stared at the screen. Never here. I live 12 minutes from my mother's house. I handle her insurance. I refill her prescriptions every month. But my sister lives closer to perception. She's louder. More visible. More emotionally persuasive. By 9 a.m., she had already posted a vague message online. Sometimes you have to step up when others won't. Comments filled in the blanks for her. By noon, I was standing outside family court holding a slim folder of documents I wasn't technically allowed to present. Medical reports from last quarter. Bank statements. Email threads. The clerk had underlined it twice in the notice. No witnesses unless pre-approved by court. I walked into the courtroom at 1:22 p.m. Room 312 smelled faintly of old paper and lemon cleaner. My sister was already seated at the petitioner's table beside her attorney. She didn't look at me. That was intentional. Her posture was composed, hands folded on the table as if she were protecting something fragile. Our mother wasn't present. "She's too confused for this," my sister had written in the filing. Too confused. The judge entered at 1:31 p.m. sharp. We stood. Then sat. Petitioner is requesting temporary guardianship due to demonstrated cognitive decline, my sister's attorney began. Calm. Structured. Clinical. He cited 3 incidents. Missed payments. A minor fender bender in March. An instance where mom called my sister at 11:47 p.m., unsure what day it was. The attorney paused strategically after each point, letting the air do the work. My sister dabbed at her eye once. Measured. Subtle. Not theatrical. Effective. Then it was my turn. I stood alone. No attorney beside me. I had chosen to represent myself. Because this wasn't about legal complexity. It was about narrative. I object to the characterization of immediate risk, I said evenly. There has been no formal cognitive diagnosis. The judge glanced at the paperwork. Do you have documentation? Yes. Was it submitted prior to today's hearing? No, Your Honor. I was notified 12 hours ago. The judge looked toward my sister's attorney. He shrugged slightly. Emergency circumstances. Emergency. The word again. Urgency creates advantage. I felt the shift in the room. Procedure favors preparation. Preparation favors the one who files first. You may summarize, the judge allowed. Summarize. I had lab results. Neurology assessments. A memory screening score from 6 weeks ago, 27 out of 30. Normal range for her age. But I could only summarize. As I spoke, I watched my sister carefully. She didn't look nervous. She looked certain. As if this outcome was administrative. Already decided. She needs stability, she said when it was her turn again. And he travels constantly. There it was. The real argument. Not cognitive decline. Absence. You're rarely available, she added, finally looking at me. The statement was calibrated. Technically true. Strategically incomplete. I consult for federal contractors. Some weeks I travel. But never without planning. Never without coverage. The judge folded his hands. This court must prioritize safety. Temporary guardianship does not remove involvement from either party. It ensures oversight. Oversight. That word tightens something in my chest. Oversight means control. Control means access. Access means decisions about finances, property, medical directives. My sister's attorney slid a document forward. Temporary guardianship pending full evaluation. I recognized the form. 6 months renewable. My mother's autonomy, reduced to a checkbox. I stood very still. Your Honor, I said, there are additional factors that should be considered before granting authority. The judge looked mildly impatient. Such as? I hesitated. Not because I lacked information. Because timing matters. I have documentation regarding recent financial movements from my mother's accounts, I said. My sister's eyes flickered. Briefly. Then steadied. Those can be addressed in a future hearing, her attorney interjected smoothly. Today concerns capacity. Capacity. Not conduct. Not motive. The judge leaned back. I will grant temporary guardianship pending medical evaluation. The words landed softly, but they carried weight. My sister exhaled slowly. Relief. Victory. Control. The gavel struck once. 1:58 p.m. 6 months, the judge repeated. We stood. My sister finally looked at me fully. There was no malice in her expression. Just certainty. You should have just agreed, she whispered as we gathered our papers. I didn't respond. Because at 2:03 p.m., as we stepped into the hallway, my phone vibrated. One message. Unknown number. Arrived. Parking secured. Advise when appropriate to enter. I read it twice. Then once more. My sister was speaking with her attorney 10 feet away, discussing next steps and asset review. I slipped my phone back into my pocket. 6 months. She thought she had secured 6 months of control. She thought the emergency framing had boxed me out. She thought showing up alone meant being alone. But emergency hearings are temporary. And some witnesses don't need court permission to stand behind you. The first time my sister told me I was too serious, we were 8 and 11. I had built a model airplane from a kit Dad brought home, glue-stained fingers, careful alignment, wings measured twice before pressing them into place. I remember holding it up, proud of the symmetry. She laughed. It's just a toy, she said, already bored, already moving on. That was always the difference between us. I built. She performed. When Dad died 15 years ago, the difference sharpened into something quieter and more dangerous. At the funeral reception, relatives kept saying, "You're the strong one," to me. They kept saying, "You're so brave," to her. Strength is invisible. Bravery photographs better. Mom leaned on both of us in different ways. I handled paperwork. Insurance forms. Estate transfers. I sat with a yellow legal pad and made columns. Assets. Liabilities. Taxes due. My sister handled people. She called neighbors. Arranged meal deliveries. Posted heartfelt messages online about loss and resilience. Everyone praised her. No one noticed who closed the accounts. That pattern repeated for years. When Mom needed her roof replaced, I met with contractors. Compared estimates down to material grade and warranty length. My sister visited once during installation, took pictures, posted, so grateful to help Mom feel safe again. The comments poured in. You're such a blessing. I stopped correcting narratives. There's a point where explanation becomes undignified. The first real fracture happened 3 years ago. Mom wanted to invest a portion of her retirement funds into a small property, a duplex 10 blocks from her house. Modest risk. Stable rental history. I ran projections. Cap rate 6.2%. Conservative occupancy assumptions. Insurance coverage mapped. My sister opposed it publicly. She shouldn't be making decisions like this at her age, she said during Sunday dinner. Mom sat at the head of the table, silent. I asked him to review it, Mom said quietly, nodding toward me. My sister's smile was thin. You always trust him with numbers. The implication hung there. Numbers are cold. Care is warm. Mom bought the duplex. It performed exactly as projected. For 2 years. Then, 4 months ago, I noticed something small. A transfer from Mom's primary account labeled Consultation Services LM. $4,800. Unusual, but not alarming. I asked Mom casually. Oh, that was for some paperwork help, she said. Your sister recommended someone. I made a note. Then another transfer appeared 2 weeks later. $3,200. Same label. I asked again. Mom seemed unsure. She said it was necessary. Necessary for what? There was no paperwork pending. No tax audit. No property dispute. I didn't confront my sister immediately. Confrontation without evidence is noise. Instead, I requested bank statements for the last 6 months. Mom had given me durable financial power of attorney years ago, a precaution after Dad passed. My sister knew that, which meant if she was moving money, she was doing it carefully. The pattern emerged slowly. Small amounts. Irregular intervals. Always labeled as consulting. Totaling $27,600 over 4 months. Not catastrophic, but deliberate. Then came the missed utility payment cited in court. Electric bill. $214. Mom had never missed a payment in her life. I checked the account history. Automatic payment had been disabled. Manually. 2 weeks before the consultation services began. That was the moment I understood the architecture. Create small administrative instability. Frame it as cognitive decline. Offer guardianship as protection. Gain consolidated access. No dramatic theft. Just reclassification. Legal control is more valuable than cash. I drove to the duplex one evening unannounced. The tenant, Mrs. Alvarez, opened the door. She's been by, Mrs. Alvarez said when I asked about my sister. Asked about renewing lease. Said things might change. Things might change. Without consulting me. Without consulting Mom. That was escalation. I didn't accuse. I didn't warn. I began documenting. Dates. Times. Screenshots. Bank routing numbers. I hired a forensic accountant quietly, paid from my own account. The report was preliminary but clear. The Consultation Services, LLC traced back to a newly registered entity. Registered 2 months ago. Managing member, my sister. She wasn't siphoning large sums. She was establishing precedent. Demonstrating that Mom required financial assistance. Charging for it. Creating paper trails of dependency. That's when I realized the emergency hearing wasn't impulsive. It was sequenced. Step 1. Introduce minor instability. Step 2. Position self as solution. Step 3. File for guardianship citing pattern. I considered confronting her privately. But people who build narratives publicly rarely retreat privately. Instead, I waited. I gathered more. Because one thing about my sister, she moves confidently when she believes the story is already accepted. And by the time she filed for emergency guardianship, she believed she had shaped perception sufficiently. She underestimated 2 things. First, that I review bank logs the way other people read news. Second, that my professional life, the one she dismisses as always traveling, intersects with institutions that do not appreciate financial manipulation involving federal contracts. The message I received in the hallway after the hearing wasn't random. It wasn't dramatic. It was procedural. Arrived. Parking secured. Advise when appropriate to enter. Appropriate to enter what? Not the courtroom. That phase had passed. Something else. Something larger. Temporary guardianship lasts 6 months. But financial misrepresentation tied to federal clearance? That lasts longer. Much longer. And if my sister believed this was just a family dispute, she was about to learn that some oversight extends beyond county courtrooms. Temporary guardianship changes the atmosphere immediately. By 9 a.m. the next morning, my sister had already emailed Mom's bank requesting updated signatory access. She CC'd me, almost generously. For transparency, she wrote. Transparency. The word has texture when it's used strategically. I responded at 9:12 a.m. Noted. Please include full documentation of all advisory payments made over the past 6 months. No accusation. Just documentation. Her reply came 40 minutes later. Those were legitimate administrative expenses. We can review later. Later. Delay is another form of control. By Wednesday, she had scheduled a financial review meeting at Mom's house. 6:30 p.m. She invited the bank representative, her attorney, and a care coordinator. She invited me as well. Formally. Like a courtesy. When I arrived, the living room had been rearranged. Mom sat in her armchair by the window, looking smaller than usual. Not confused. Just tired. The bank representative, a young man named Connor, sat at the dining table with a laptop open. My sister stood beside him, hand resting lightly on the back of Mom's chair. Positioning. I just want everything streamlined, she said as I walked in. Less stress for her. I nodded and took a seat opposite Connor. What exactly are we streamlining? I asked. Consolidating account access, she replied smoothly. Reducing redundant oversight. Redundant oversight. Meaning mine. Connor cleared his throat. We've received a request to add Ms. Hale as primary financial guardian per court order. Temporary guardian, I corrected calmly. Of course, he said. My sister smiled faintly. This isn't adversarial, she said. We're family. Mom looked at me then. Not pleading. Just searching. Is this necessary? She asked quietly. My sister squeezed her shoulder. It's just paperwork, Mom. Paperwork. That word again. Paper can move houses. Paper can move money. Paper can move autonomy. I opened my folder, the same slim one I had brought to court but hadn't been allowed to present fully. Inside were printed bank statements, highlighted lines, incorporation documents for LM consultation services, and a preliminary forensic summary. I didn't slide them forward yet. Timing matters. Connor began reviewing account structures. Primary checking. Retirement fund. Rental income account for the duplex. Given guardianship status, Connor said carefully, there may be a review of recent transactions. My sister's posture shifted slightly. What kind of review? She asked. Standard compliance, he replied. Particularly when there are related party entities. Related party entities. The phrase landed softly. I watched her face. She recovered quickly. There's nothing improper, she said. I've been helping Mom. I'm sure, Connor replied diplomatically. He typed something into his laptop. His brow furrowed. Miss Hale, he said, turning the screen slightly toward her, can you clarify this LLC? She leaned forward. That's the consulting service I mentioned. For what services exactly? He asked. Administrative coordination. Bill payments. Lease discussions. Do you hold a financial services license? The question was neutral, but precise. She hesitated half a second. No, but... And was this disclosed in the guardianship filing? Silence. I finally spoke. The filing cited cognitive decline as the basis for urgency, I said evenly. It did not disclose paid advisory arrangements. Mom looked between us. Paid? Her expression changed, not confusion, but realization. I thought that was just helping, she said softly. It was, my sister insisted quickly. It was minimal. Minimal. $27,600 minimal. Connor cleared his throat again. Given the involvement of a newly registered LLC receiving recurring payments from a vulnerable account holder, he said, choosing words carefully, our compliance department may need to file a review. Review. Not accusation. Not fraud. Just review. My sister straightened. This is ridiculous, she said. You're making this something it isn't. I'm making sure everything aligns, I replied calmly. She turned to me sharply. You're never here. You don't see the late-night calls. The confusion. I see the bank logs, I said. The room tightened. Mom's hands trembled slightly in her lap. Enough, she said quietly. Silence followed. The bank representative closed his laptop slowly. I'll escalate this internally, he said. No immediate changes until compliance review is complete. Translation. No consolidated control yet. My sister exhaled sharply. Fine, she said. We'll handle it formally. Formally. That meant escalation. Court. Medical evaluation. Narrative reinforcement. She wasn't backing down. As we stood to leave, she stepped closer to me, lowering her voice. You think paperwork scares me? She asked. No, I replied. But oversight might. Her eyes narrowed slightly. You don't have any leverage. I held her gaze for a moment. Then my phone vibrated again. Same number as before. Single line. Clearance verification complete. Awaiting your signal. I looked at her. You're right, I said softly. Not here. Confusion flickered across her face. Because this wasn't about winning a bank meeting. It wasn't about persuading a local judge. It was about exposure thresholds. And she had just triggered one. 2 days later, the court scheduled a follow-up evidentiary hearing. Medical evaluation results pending. Financial disclosures required from both parties. Both parties. She walked out of the house that night believing this was still manageable. Still family-sized. But the moment financial misrepresentation intersects with federal compliance, it stops being local. And next week's hearing wouldn't be limited to family court. It would include someone she had never anticipated standing in that room. The evidentiary hearing was scheduled for Tuesday at 10 a.m. Family court, same building. Different room. Room 417 this time, slightly larger. Better lighting, more seating. Word had spread quietly through extended family. 2 cousins sat in the back row. An aunt who rarely attended anything arrived 10 minutes early. My sister came prepared. Navy blazer. Soft expression. A folder thicker than mine. Her attorney looked confident, not aggressive, just steady. The kind of steady that comes from believing your narrative is cleaner. Mom was present this time. She insisted. The court-appointed evaluator had conducted a cognitive screening the previous afternoon. I had been there. So had my sister. Mom scored 26 out of 30. Mild age-related memory variance. Not incapacity. But ambiguity can be persuasive. The judge entered at 10:02 a.m. Today we review financial disclosures and medical findings, he began. Temporary guardianship remains in place pending clarification. Clarification. The word was neutral. But I could feel the tension increase. My sister's attorney presented first. He acknowledged the LLC payments, but framed them as compensated assistance during documented periods of confusion. He emphasized Mom's late-night calls. He referenced the missed electric bill again. He presented printed screenshots of text messages, carefully selected ones, where Mom asked basic questions twice. He built a mosaic. Small tiles. Patterned toward decline. Then he addressed the LLC directly. Ms. Hale registered a consulting entity to formalize assistance, he said. Transparency through structure. Structure. That word again. He avoided the total amount paid. Instead, he referenced monthly stipends. The judge took notes. I waited. Silence is not passivity. It's pacing. When it was my turn, I stood and approached the lectern. No attorney beside me. Just the folder. Your Honor, I began, voice steady. I do not contest that my sister assisted our mother. I contest the representation of necessity and disclosure. I handed copies of the forensic summary to the clerk. Not dramatic. Just paper. The judge reviewed the first page. Total paid to LM consultation services, $27,600 over 4 months. Breakdown of transfer dates. Correlation with disabled automatic payments. The room shifted slightly. My sister kept her posture composed. It was administrative, she repeated. Yes, I said. Administrative services provided by a party simultaneously petitioning for guardianship. Her attorney interjected. That is not unlawful. I did not say unlawful, I replied calmly. I said undisclosed in the initial emergency filing. The judge looked at the guardianship petition again. There was no mention of paid advisory relationships. Only unpaid caregiving. The omission was subtle, but material. Then the judge asked a question that changed the temperature. Ms. Hale, are you currently employed? My sister blinked once. I consult independently. For whom? Various private clients. Any federal contractors? The question felt precise. Targeted. She hesitated. One, she said carefully. Which one? The judge asked. She named it. A mid-tier defense logistics contractor. I watched her carefully. Because this was the intersection. Her consulting agreement, filed publicly for procurement transparency, included a compliance clause regarding financial conduct and conflicts of interest. Her LLC receiving undisclosed payments from a vulnerable adult while petitioning for legal control created a potential reporting obligation. Not criminal, but reviewable. The judge leaned back. Given the financial entanglement and omission in initial filing, he said slowly, This court requires full disclosure of all compensation received from Ms. Hale's consulting entity and its impact on her external contracts. There it was. Scope expansion. My sister's attorney stiffened. With respect, Your Honor, that extends beyond the immediate guardianship question. It intersects credibility, the judge replied evenly. And credibility determines guardianship. Then something unexpected happened. The courtroom door opened quietly. A man in a gray suit entered, carrying a slim briefcase. Mid-40s. Composed. He approached the clerk and handed over identification. The clerk whispered to the judge. The judge looked up. Sir, state your name and capacity. He stepped forward. Michael Grant. Defense Compliance Liaison, Office of Federal Contract Oversight. The room went still. My sister turned toward me slowly. I remained seated. I'm here, he continued calmly, to clarify that any consulting relationships tied to federally contracted entities require immediate disclosure of potential financial conflicts, including pending litigation or guardianship disputes involving fiduciary control. My sister's face lost color. Not dramatically. Just gradually. Because this was no longer a family disagreement. It was a compliance inquiry. Her defense contractor client was obligated to report risk exposure. Risk exposure includes reputational and fiduciary concerns. The liaison didn't accuse. He didn't threaten. He simply placed a letter on the clerk's desk. We request documentation under Standard Review Protocol, he said. Standard Review Protocol. The judge nodded slowly. This court welcomes full transparency, he said. My sister's attorney leaned toward her, whispering urgently. She stared forward. The confidence she carried into the room had thinned into calculation. Because she understood something now. Guardianship was leverage. But federal compliance was consequence. And consequence doesn't negotiate emotionally. The judge spoke again. Temporary guardianship is suspended pending comprehensive financial disclosure and compliance review. Suspended. Mom inhaled sharply beside me. My sister didn't look at her. She looked at the liaison. Then at me. For the first time since filing the petition, uncertainty replaced certainty in her expression. Not panic, but realization. This had expanded beyond her control. And as we stood to leave, she stepped closer, voice low. You did this, she said. I met her gaze evenly. No, I replied. You structured it.